Scene.
Welcome back to the Law and Crime Network. I'm Heather Hansen, and our first guest this afternoon is Kendall Coffee. He is a former U.S. prosecutor from Florida and here to talk to us about the Matose case and what the heck these defense attorneys are doing. Welcome this afternoon, Kendall.
Hey, thanks for having me on. It's a horrible and yet fascinating case and strategy.
It sure is. I want to talk to you. You know, I've been watching this morning, and our hosts, Jesse and Stephanie, were really in awe of the fact that the defense attorneys have not questioned hardly any of the witnesses, even in those situations where you would think that there would be things that you actually could cross-examine. Why do you think that is?
Well, I think they recognize that this is a horrible crime, 4 murders, in some instances, extreme brutality in the manner of death, and that the evidence is absolutely overwhelming. What do you do in a case like this? You hope that at the end of the trial, where you expect guilty on everything, you've still got some jurors who might have an open mind to not sentencing your client to death. As you know, in very difficult capital murder cases, it's a huge win for the defense if rather than death sentence, their client is sentenced to life imprisonment. That sounds like an odd goal of a strategy, but in some cases, that's the best you can possibly hope for.
Yeah, and I agree with you, Kendall. I think that that is the plan. I was sort of on the fence. I thought that perhaps they were going to put forward this alternate theory that someone else may have done the crimes, or perhaps have him come in and testify himself in this case. But the unfortunate reality is, for the defense, the evidence is overwhelming here that he did it. And so rather than trying to put up a defense that would, in many cases, maybe even offend the jurors, I think it may be a smart defense to do as you said and to try to save his life rather than to try to get him a not guilty plea, a not guilty verdict. But what do you think about this idea of trying to get it to be something less than first-degree murder? Do you think the defense had any option to pursue that type of cross-examination to make for that type of defense?
I think that's hopeless, even though in many instances somebody just reading about a case might say, well, the defense lawyer should be fighting the guilty part of the case and trying to raise every possible issues, kind of nitpick the evidence, whatever they can do to try to raise a reasonable doubt. And then if that fails, then pivot into the death penalty phase and try to get a juror to save the life. But that's not always realistic, because you can further alienate. It doesn't seem possible that, given the evidence, the jury could be more alienated than they are with respect to this defendant. But you can make things worse if you keep it going longer. Sometimes a prosecution witness finishes. You don't want to get up there and nitpick them for 5 or 10 minutes and then have the prosecutor come back and reemphasize even more the fact that, for example, one of the victims, allegedly, we say allegedly at this point, Meghan Braun, had her hands tied, had her mouth duct taped, was really killed in a cruel way. Why play that out even longer and even more than the prosecution is already developing that kind of grisly detail?
And you make a fabulous point there, Kendall, because one of the witnesses that actually was cross-examined, and we don't have that many, was the medical examiner. And it appeared to me that that cross-examination focused on the fact that many of the wounds may have been inflicted after death, which sounds absolutely like something a defense attorney wouldn't want to do. But if you're talking about how cruel the murders were, that's something that may be used in mitigation. So if that's the case, why wouldn't the defense attorneys give an opening and lay out that you know, this is not a bad guy, and that he is, or that, you know, we beg for your mercy, as opposed to just remaining silent and keeping the jurors wondering what it is that they're doing?
It's a controversial strategy anytime you don't do an opening at all. But if you conclude and you make these game time decisions, I apologize, the sports analogy, but if you're looking at the jury after the prosecution is finished and you think they are angry, that they are outraged, that they are incensed, and they're already in a feeling like they should put your client on death row, to get up and talk about things that may seem trivial or small in the scheme of things just doesn't make it any better. You've got to hold whatever shreds of credibility you may have at the end of the trial for trying to persuade them that there's a reason to show mercy. Under Florida's new law, it just takes one juror. who doesn't want your client on death row in order to save your client's life.
So if that's the case, now we expect the prosecution to rest tomorrow. They said that they're going to run out of some witnesses this afternoon, as sometimes happens, and then call some people tomorrow and then rest. Do you think we'll hear anything from the defense side, any evidence whatsoever in this stage before we get to the death penalty stage?
I don't think we will. Given the brutality of the crimes, given all of the evidence, there just isn't an occasion to try to talk to a jury about manslaughter or something less than premeditated intentional murder. And witnesses at this point are not going to be permitted to talk about the specific mitigating circumstances. The judge knows that this is just the guilt phase. So I don't think there's any witness that can be put on that could make a difference in terms of the outcome of the guilt or innocence. And the last person that the defense wants this jury to be hearing from is, of course, the defendant, Adam Matos.
That's an interesting point and something that's been debated here at this very table. I agree with you, but why do you say that, Kendall? Why do you, and there he is on our screen, why do you think that he is the last person that the defense wants to put on the stand?
Because all the evidence shows that he brutally murdered these people, and there's no value in him trying to challenge the guilt or innocence. And if at some point they want him to get on the stand and talk about, let's use examples from other trials, a really horrible childhood, some circumstances, overcoming drug abuse, whatever they think he might be able to talk about in the sentencing phase, the judge isn't going to let him talk about that now. So right now, all that can be discussed is whether or not he perpetrated these crimes, and there's nothing that this defendant can say that is going to affect that. And by the way, defense lawyers have a duty not to put a client on to provide patently false testimony. If there's nothing he can say to contribute toward his innocence, there's no basis to put him on at this point.
I'm looking at the chat room, and Katie just said, you know, that she agrees with you, and one of the reasons why is because there was no opening. I think that all of the signs are pointing to no defense here. And the other problem for Matos is that if he testifies, the other things that he has been accused of and in fact convicted of in other jurisdictions may come up. Apparently he had a situation where he was had a similar situation where he had a confrontation with an ex-girlfriend or a girlfriend's new friend, and that type of thing is certainly not going to help him in this case. The other thing that has led me to this conclusion is if it's true that Matos has signed off rights to his child, that too may sort of support the idea that he's willing to spend the rest of his life in jail to escape the death penalty. That would also, Kendall, explain why there wasn't a plea in this case, wouldn't it?
Yeah, there's no point in a plea because there is no Florida prosecutor that I can think of that is going to take the death penalty off the table. And of course, that's the object of a guilty plea in a first-degree murder case. So if the death penalty is going to be something the prosecutor insists on trying to get, defense lawyers really are not in a position to make a guilty plea. As to what can be done in the next phase, we're all going to be fascinated to see what the defense can develop. But for this phase, I think the defense is essentially done with whatever they can try to do.
Kendall, we're so lucky to have you here because of your experience in Florida. When you say that there's no prosecutor who would take the death penalty off the table, why is that? Is that because the community is so, especially with a case like this one, is so upset and incensed, or is there some political reason or a combination?
Well, I mean, of course, in our state system, the prosecutors are elected. They read the newspapers. They're not indifferent to community decisions. I think in death penalty cases, they make decisions based upon conscience. But they also have a commitment and an obligation to respect the death penalty. When I was a U.S. attorney, I didn't then, I don't now believe in the death penalty. But that doesn't mean that I wouldn't be obligated to approve it if there is an overwhelming factual and evidentiary basis to impose a death penalty, because that's the law. They're all sworn to uphold the law. You've got 4 brutal murders. No justification that anyone can think of. At least one of the murders appeared to be in a very cruel manner. And there's simply, beyond that, the most callous kind of thing. According to the evidence, he goes out and sells some of the belongings of the people that are murdered. Everything about this case tells you that If there is ever a case that deserves the death penalty within the Florida system, this has got to be that case.
Yeah, I mean, what you're right about, we're all eager to see, if there's a conviction, we don't want to put the cart before the horse here, but the death penalty part of this case, because the prosecutor is once again going to have some very strong evidence to support the aggravating factors that have to be proven in order to bring death penalty. You mentioned some of them. Why don't you just, so that we're clear to our audience, why don't you go through some of them again, the aggravators here?
Well, and Florida's new law, Florida used to have one of the most prosecution-friendly, defendant-unfriendly laws in the country, and made it much easier for prosecutors to get a death penalty. After the courts knocked it out a couple times, in March of this year, the legislature, with the governor's approval, finally enacted a death penalty law that appears to be constitutional. As we talked about a moment ago, it requires a unanimous jury. And there have been significant cases in which there's a single holdout juror that ends up in saving the defendant's life. So what the prosecution has to establish is at least one aggravating circumstance that's unanimously approved. Here they're going to be looking at an important circumstance is the premeditation. Was this a crime that really looks like it was thought about? It wasn't an impulse, horrible tragedy in a split second, but something that was really thought about and perpetrated with complete premeditation. That's a factor. We talked about a little earlier about how if a crime is especially cruel or heinous or atrocious, this crime, according to the prosecution, easily fits that. There may be a discussion, and you talked about earlier, why would it matter to the defense to try to show that injuries were inflicted after the death of the victim? Why does it matter? Doesn't it show horrible brutality in either event? Well, the cruelty of the crime is what takes place while the victim is still alive. And while as human beings, we're all aghast when we hear about people who are murdered, and then there's, to use this unpleasant word, mutilation. That mutilation is, of course, something that doesn't add to the cruelty of the actual extinguishment of life in the first instance. The fact that there are multiple victims here and multiple threats of safety is also an important character. So this is a case where there are at least three very strongly anchored aggravated circumstances, and they may be able to show one. But under Florida's law, you just have to establish one to the unanimous agreement of the jury.
And then this is a wonderful help about Florida, Kendall, because in the past, some of our chatters have asked us to explain mitigators. Now, in this case, how would mitigation work, and what type of evidence would the defense be putting on for mitigation?
Well, the mitigating circumstances under the statute are relatively few. For example, there's no prior criminal history. That's an important mitigation circumstance. But what the U.S. Supreme Court has sort of read into the laws, that the defense has to, because life and death is the issue, be allowed to present whatever circumstances can credibly provide a reason why somebody's life should be spared. And so they very often get into the circumstances. And I wasn't speaking facetiously when I talked about a brutal childhood. That's a reality that often does contribute to murderous propensities. And even though there's no form of alcoholism or drug addiction that can take you away from criminal responsibility in the first instance, those circumstances, if they're present, can be considered in the sentencing phase. On the other side of it is, of course, victim impact testimony. And family members are going to be able to talk about, of the victims, how upset they were, how much they loved that person, what a devastating, cruel horror this has been in their lives. And so even if a defendant can create some element of sympathy, it can be very hard to overcome victim impact testimony along with the other aggravating circumstances that we can readily envision will be part of the prosecution's case during the sentencing phase.
You know what, Kendall, you have been an enormous help in explaining a lot of the issues that many of our chatters have been asking to have explained for some time. So we so appreciate you coming on. I want to sort of wrap up this interview by asking you, what do you think, and I know that this is reading tea leaves and none of us know what will happen here, but what do you think as far as the liability phase, and then how long do you think the death penalty phase will last, and how will it come out?
Well, I think it's again, we shouldn't, sometimes you can never predict, but we're realistic. We know that it's a foregone conclusion. He's going to be found guilty of 4 counts of first-degree murder. I think the sentencing phase will indeed be the battle that defense is focused on. I think it'll be more than a week, less than 2 weeks, and I think it's going to be very, very uphill to keep Adam Matos from joining close to 400 people that are already on Florida's death row.
Kendall, thank you so much for your time and your expertise, especially in this area. It's great to have someone on from Florida. We'll be sure to have you back again.
Well, thanks for including me. Hope I'm invited back.
Have a great day.